Hi everyone. On behalf of SCC online team, wishing you all Merry Christmas. May the true spirit of Christmas shine in your heart and light your path. In this episode, I have got for you some interesting updates from all courts and legislation updates. Also, don't forget to watch the video till the end to find out the winners of this week's SCC online quiz. The Supreme Court, in a very recent observation, has held that the bank is not the trustee of the money that a customer deposits in a bank, and the same is not held by the former on trust for him. The money so deposited become a part of the banker's funds, who is under a contractual obligation to pay the sum deposited by a customer to him on demand with the agreed rate of interest. The court also said that such a relationship between the customer and the bank is one of a creditor and a debtor. In a case where the CRPF had initiated a disciplinary proceeding against a person with a medical history of obsessive compulsive disorder and depression, has been undergoing treatment for the same since 2009. The Supreme Court has held that the initiation of the disciplinary proceeding against persons with mental disability is a facet of indirect discrimination, as such persons suffer a disproportionate and disadvantage due to the impairment and are more likely to be subjected to disciplinary proceedings. The court also observed that disability needs to be one of the factors that led to the discriminatory act, and that any residual control that persons with mental disability have over their conduct merely diminishes the extent to which the disability contributes to the conduct. It does not eliminate it as a fact. In a case where it was alleged that more than one consumer cannot institute a complaint unless they come within the definition of the word complainant of Section 2 Clause 5 of the Consumer Protection Act 2019 and also satisfy the requirements of Section 38 Clause 11, read with Order 1 Rule 8 CPC, Supreme Court has held that it is wrong to contend that wherever there are more consumers than one, they must only take recourse to Order 1 Rule 8 CPC even if the complaint is not on behalf of or for the benefit of all the consumers interested in the matter. While the court agreed to the fact that the definition of the word complainant is little misleading, however explained that there may be cases where only a few consumers and not numerous consumers have the same interest. The court noticed that there is nothing in the Act to prohibit these few consumers from joining together and filing a joint complaint. The Kerala High Court reversed the concurrent findings of the lower court, whereby the accused was convicted for the offence of rape, and while acquitting the accused, the court expressed that the mere statement by the victim in her evidence that the accused hugged and impregnated me without indication about penetration aspect is not sufficient to attract the offence of rape. Such vague statement would not be a substitute for the statutory mandate as contained in explanation to Section 375. In another very interesting matter, the Kerala High Court set aside the findings of a family court, wherein it had rejected to grant divorce, holding that providing maintenance is sufficient for husband to meet marital obligations, opining that unequal treatment between wives is sufficient ground to dissolve marriage under the Muslim law. The bench remarked that the refusal to cohabit and perform the marital obligations with the previous wife is tantamount to the violation of the Quranic injunctions, which commands equal treatment of the wives if the husband contracts more than one marriage. The division bench of Delhi High Court, while addressing a very unfortunate incident involving sexual offences to the extent of rape and carnal intercourse with a child, expressed that to sexually violate an innocent child is in any case an abhorrent act, but when that happens within the filial father-daughter relationship, of which purity of affection is a sine qua non, the act descends to a different depth of depravity. To read the detailed report of this decision, please check out on SCC online blog. The Madras High Court noted that a video clipping showing the online court proceedings of one of the brother judges, in which a male was found engaged in eroticism with a lady, was going viral on social media. The High Court stated that it cannot afford to be a mute spectator and turn a Nelson's eye when such a brazen vulgarity is publicly displayed amidst the court proceedings, criminal contempt proceedings. While dealing with an absurd FIR filed over FB post, the Madras High Court stated that Jag Suraya, Bachi Karkaria, EP Uni and G Sampath, if any one of them, or for that matter any satirist or cartoonist, had authored this judgment, they would have proposed a momentous amendment to the Constitution of India to incorporate subclause I in Article 51A. The Madras High Court expressed that to Article 51A, the hypothetical author would have added one more fundamental duty, that is duty to laugh. The bench stated that right to be funny can be mined in Article 19(1)(a). Expressing further, the court stated that laughing at what is a serious question. Please check out the SCC online blog to read the detailed report. Moving on to the legislation updates. On December 20th, 2021, a mediation bill has been introduced in the Rajya Sabha with an object to promote and facilitate mediation, especially institutional mediation, for resolution of disputes, commercial or otherwise. The bill introduces a period of 180 days for completing the mediation process, which is further extendable to a maximum period of 180 days with the mutual consent of the parties. It also provides for compulsory pre-litigation mediation in matters of civil or commercial dispute before parties approach to a court or tribunal as provided. On December 21, 2021, the Rajya Sabha has passed the Election Laws Amendment Bill 2021. The bill was passed in Lok Sabha on December 20th. The bill seeks to link electoral rolls with Aadhaar number. It also provides that the electoral registration officer may require a person to furnish the Aadhaar number given by the UIDAI as per the provisions of the Aadhaar Targeted Delivery of Financial and Other Subsidies, Benefits and Services Act for verification of their identity. Parliament passed the Assisted Reproductive Technology Regulation Act 2021 on December 18. The bill seeks to regulate ART clinics and banks organization and to ensure ethical practice in a long unregulated sphere. On December 22, the Legislative Assembly of Karnataka introduced the Karnataka Protection of Right to Freedom of Religion Bill 2021. The bill provides for the protection of the right to freedom of religion and prohibition of unlawful conversion from one religion to another by misrepresentation, force, undue influence, coercion, allurement, or by any other fraudulent means. The bill proposes for imprisonment for 3 to 5 years with a fine of Rs 25,000. Now coming to the most awaited section of this episode. In this week's SCC Online quiz, we have asked our viewers how many topics are sub-indexed in curated topics on SCC Online web edition. So the correct answer is 5. And the winners are Prab Simran Singh and Yash Bhatt. Congratulations to both of you. Thank you for watching this episode. Stay tuned to our next episode of SCC Online Weekly Rewind.